It is.
I forgot that I scheduled I thought I'd stolen 15 minutes from this. Okay, folks, let me, first of all, I really want to take this opportunity to thank publicly Grace Tully. I mentioned her last night, but this is my assistant. Thanks so much. And I'm afraid I didn't find Jill DeYoung, but she's out there somewhere. She's hiding, and I threatened to thank her too in public, but I do want to mention her name too. Thanks very much, Grace, for all you've done. The other thing I realized, one important business item that I left off, or just an announcement, but we are facing the problem that Blanche Kapelos is retiring, and is Blanche in here? Is she already gone? Oh, shoot. Well, I should have thanked her on behalf of the society too, but let me publicly say that we do want to acknowledge the tremendous contribution she's made over the last, what has it been, 4 years or so? 5 years as our executive assistant. But what it means with her retiring is that we are going to need to replace her. And so just to remind you, the arrangement is that we as a society pay $25,000 subsidy to a host school. Oh, sorry, $10,000. Thank you. Good thing we've got the guy with the money here. I'm writing these blank checks. $10,000 subsidy for a position like that to the host school. Connecticut, in this case, has made Blanche available to us, so we're going to be looking to see if there are any member schools that are interested in having that arrangement in the future. And so, again, we'll send a message out from the executive committee making that clear, and Patrick told me to make that announcement. Okay? So I guess we're ready to start the panel, and I'll turn it over to my colleague, John Carlson.
Good morning. My name's John. I'm going to wreck this. My name's Jonathan Carlson, and I'm going to be the moderator, which I guess means really the timekeeper for this final panel. Professor Wright shared some helpful comments with me about his intentions and goals for this panel, and so I just want to say a couple of words of introduction, and then we'll move on. Today's panelists are going to address two major issues concerning the future of judicial review. First, what does our experience teach us about the role of judicial review in public international law systems? Is it useful? Is it problematic? Or more likely, is it both? Second, will China adopt, or rather will it expand its use of judicial review, and to what end? Professor Wright, I think, selected those topics and these speakers because they relate to the broader themes of the conference in an important way. Both public international law and the Chinese legal system lack the legitimacy that we say attaches to law coming out of electoral democracies. And the question is raised, can judicial review somehow provide a different kind of legitimacy for those legal systems, or does it even further weaken the legitimacy of those legal systems? And perhaps scholars will find that the answers to those questions are contingent completely upon context, and that there isn't any general answer one can give. We have three excellent speakers this morning. Richard Kay, professor at the University of Connecticut Law School. My colleague, Alexander Somek, professor here at the University of Iowa College of Law, currently visiting at Princeton, so it's nice to see him back. And Neysun Mahboubi, research fellow at the University of Connecticut. Professor Wright assures me that they need no introduction, so I didn't try to prepare one. The introductions are in the papers. The plan is that each of them will speak for 20 minutes, leaving about 30 minutes for discussion. And so, gentlemen, please remember, it's not a presidential debate. You can stick to the time limits and be kind to your moderator. No one will think you weak.
Thank you very much. I'd like to thank John and the organizers of the conference. This has been a wonderful experience all around. This panel, as our chair has said, I understand it as well, to be about judicial review in some particularly problematic settings. In my case, and in probably my colleague Professor Somek's case, about judicial review exercised by an international court, and more particularly for my presentation about the judicial review that occurs in the European Court of Human Rights. And the European Court of Human Rights, as you know, has already made a number of cameo appearances in this conference, but will be the star in my part of it. You might think that international judicial review is plagued with certain special difficulties, especially insofar as we are worried about judicial review's consistency with democratic decision-making. At least some of the explanations, the justifications for judicial review that have been put forward, in light of that problem with respect to national courts, I think turn out to be sort of non-starters in an international court, because to the extent, anyway, that we think of that problem, the democratic deficit, the counter-majoritarian problem, as a problem that refers to the approval of the people of a nation state, put it in a maxim, which you've sure heard before, no demos, no democracy. So with that background, let's consider the European Court of Human Rights. Now, it's always kind of a problem when I talk to people, even a very knowledgeable audience like this, about the European Court of Human Rights, because a fairly wide-ranging amount of familiarity with it. So I'll deal with it by kind of a galloping summary of the nature of that court. This is something which I'm sorry will be no doubt boring for many of you and inadequate for the others. The European Court of Human Rights, arguably the most successful international court in the history of the world. From very modest beginnings, it has become, in about 50 years, the human rights constitutional court for Europe. It reviews claims of violation of the European Convention of Human Rights, and critically, it may do so on the application of any person who claims that a party state has violated his or her convention rights. The parties to the convention are all of the members of the Council of Europe, and it's important to keep that in mind. This is a much larger group than the countries in the European Union. Currently 46 countries with a population of about 800 million people. In 2011, the court received 64,000 applications, and it issued about 1,100 judgments. At the end of 2011, there were 150,000 pending applications, which is actually doing a little better The success of the court, the impact of the court, however, has to be measured in more than quantitative terms. The court's judgments have had a visible impact on the shape of national law, and especially in particularly controversial fields. So to give you some examples, the European Court of Human Rights has held that Ireland's sodomy laws violate the Convention right of privacy. Turkey's security courts violate the right of fair trial. France's failure to provide a way for Carlos the Jackal to contest his solitary confinement violated his right to pursue a remedy for human rights violations, as well as many, many more prosaic but still very important interventions in domestic legal systems. It is generally considered, although this is something which we can talk about, that these judgments have been effective, measured on some sort of undefined scale. But certainly they seem to be effective in the sense that the state's party have changed their practices, changed their laws to conform to the court's holding about the extent of their obligations. But there have been some exceptions. And sometimes the responses take a long time. My conclusion will be that at the end, they pretty much always come around. But what I want to talk about first today is those exceptions. The exceptions to the rule of compliance, cases of resistance. And I want to mention two kinds of compliance problems. First, what I'd call non-compliance with European court judgments for practical reasons. Obviously, some kinds of violations are easier to remedy than others. So if an individual or a small number of individuals are being improperly detained, they can be released. That's not hard. Or paying compensation to an applicant whose property has been wrongly confiscated. Or even amending a statute. Other kinds of violations, however, are symptoms of deep structural problems that require substantial resources to deal with, like the chronic understaffing of the judicial system or a long neglected penal system. For some reason, the latter kinds of cases seem to be arising more frequently in recent years. And I say for some reason, but probably it's in large part because of the rapid expansion of the human rights system east to the countries of Eastern Europe. These are, in general, poorer countries and also countries with a less developed historical sensitivity to human rights concerns. So, for example, it's not surprising that Russia has been unable to create a minimally humane penal system in response to many Strasbourg judgments finding violations of Article 3 of the Convention. But I want to stress that these problems are not peculiar to Eastern European countries, and I could say that Italy seems to have had an equally difficult time over a long period in assuring that its judicial proceedings move along in a minimally satisfactory speed. So that's one kind of non-compliance. The second kind of reason for non-compliance is probably more interesting for the topic of this conference. And that's what I would call political resistance to a judgment. A political objection to the actions that need to be taken to comply with the judgment, but in addition, I think critically, in addition to the objection to what the court obliges you to do, an objection to the fact that the order comes from a source which has no legitimacy or inadequate legitimacy in the defendant's state. This has been an occasional problem throughout the history of the convention. And I would think up to recently, the most salient example has been Turkey's resistance to a series of cases which was based on property lost to residents of northern Cyprus, Greek residents of northern Cyprus, after Turkey's invasion. And Turkey resisted this judgment on principle, on the ground that it had no jurisdiction in northern Cyprus, and it did it for many years. It was a big problem in the Council of Europe, but even that case, in the end, it finally gave ground and agreed to a tribunal for adjudicating those claims. And I want to talk a little slightly more detail about a more recent case of pushback to a Strasbourg judgment, and this is one actually which Steve Gardbaum mentioned yesterday in his presentation, and that comes from the United Kingdom. And I mention it in part because it highlights the special problems of legitimacy associated with judicial review in an international setting. The United Kingdom was one of the original parties to the European Convention. It was the very first to recognize the jurisdiction of the European Court of Human Rights. It has, in fact, over the years, suffered a lot of adverse judgments in Strasbourg, and these judgments have often been resented quite publicly. In part, the British coolness towards Strasbourg judgments stems, I think, from the widely held notion that it is more or less ridiculous to think that foreigners could possibly have anything to teach the British about human rights. And periodically, after an unpopular decision, politicians have made noises about withdrawing from the system. Most recently, that has been the case with this case of the court's judgment that voting rights, that prisoners must be given the right to vote, or more specifically, that the United Kingdom's law that absolutely bars any prisoner in custody from voting violates the convention, Article 3 of Protocol 1, which obliges states to provide for the free expression of the opinion of the people and the choice of the legislature. So there was a judgment that the UK law violated that Article 3 of Protocol 1 in 2005. The United Kingdom government dithered and delayed, and then in 2010 a second case comes to the European Court. This time the court reaffirms its judgment, and it gives the UK 6 months to propose new legislation. Just to propose a legislation, and then some undefined amount of time to get it enacted. So this comes to the House of Commons. The matter is put to a free debate in the Commons, and the Parliament overwhelmingly votes to keep the law just as it is. A deadline, as I say, had been made 6 months. About 2 months before the deadline, at the request of the UK government, the European Court agrees to extend the deadline 6 months until after the Grand Chamber of the court issues a judgment in another case raising the same issue, this time against Italy. The UK intervenes in that Italian case and effectively argues you should just reverse the judgment, your previous judgment. This past May, the court decided that case, reaffirming its case law, emphasizing again how little it's asking, that the manner in which the compliance can occur here is really largely up to the state. You just can't do exactly what you're doing. But it issues the judgment, and again the clock starts ticking. And so that the deadline is now 22 November of this year, so sometime this month. Well, the media and the officials in the United Kingdom howled, and the criticism was more or less what you'd expect given the kinds of objections to judicial review in general that we have talked about here. Partly, of course, the objection was just to what they ordered Britain to do to prisoners voting. Prime Minister Cameron said the thought of prisoners voting made him physically ill. But at least as much, the criticism also focused on the legitimacy of the court's decision. And when asked at question time whether the Prime Minister would stand up to the Strasbourg diktat, Cameron said the short answer is yes. And then he went on to state the counter-majoritarian difficulty in a phrase, crucially, I believe this should be a matter for Parliament to decide, not a foreign court. Likewise, Norman Tebbit, I don't know if anybody remembers Norman Tebbit, who was a Tory minister a while back, in his blog, who would have thought Norman Tebbit would have a blog, referred to, quote, unelected foreigners who would usurp Parliament's power. Unelected foreigners who usurp Parliament's power. The day after that judgment, there's a column in the Sunday Telegraph, co-authored by Jack Straw, the former Labor Justice Secretary, and David Davis, the former Tory Minister for Europe, arguing, first of all, and not at all unreasonably, that the judgment was wrong. It was a bad interpretation of the convention. I can see that. But then they urged defiance of the court. And they predicted, moreover, that democratic parliaments across Europe will be forced with increasing regularity to choose between the will of their people and the will of foreign judges. They'll have to choose between the will of their people and the will of foreign judges. The gist of that column, I think, also remarkably was, since they got it so wrong, if they had gotten it right, well, then, of course, we would want to comply. Well, having noted this kind of reaction, however, my real conclusion will be that this is an exceptional reaction. Much, much more often, member states react to a controversial judgment against them with quiescence, if not docility. As I have noted, even most cases of noncompliance are defended, the noncompliance is defended as a practical matter, not as a matter of principle. This complacency is illustrated by the rather tepid reaction from the Council of Europe states earlier this year to an attempt by Britain to formally put curbs on the court. This was the main project of Britain's chairmanship of the Council of Europe, and they had proposed several changes to the convention, including codifying deference to the states. The court in general has a policy of deference to states, and Britain wanted to essentially put this as part in words in the convention, and especially when the court was dealing with a matter which had already been dealt with by the domestic courts. It wanted to include making complaints to the convention, to the court inadmissible when the same subject had been reviewed by a national court and that national court had not, quote, clearly erred. And I wanted to create an advisory opinion procedure, which also, for reasons I needn't go into, would have sort of restricted the jurisdiction of the court somewhat. At the end, all of these proposals were thoroughly watered down and mainly reduced to a proposal by the Council Heads of State to include in the preamble to the convention a nod to the doctrine of subsidiarity. Well, this brings me to my conclusion. Notwithstanding the inevitable irritation at interference in national decision-making by a, quote, court of unelected foreigners, end quote, the judicial review exercised by the European Court of Human Rights does not, I think, seem to be in serious jeopardy of being substantially whittled down. And I'll just quickly mention two factors that contribute to this extraordinary demotion of both democratic decision-making and national sovereignty. First, the European human rights system, I think, has piggybacked on the success of the European Union and the European idea generally. Whatever hit the European idea has been taking in the last couple of years, it still, I think, has become a fact of life, of everyday life for most Europeans, including, at least in EU states, the routine presence of regulatory decision-making at the European level. And even in the non-EU states, the European idea represents a powerful aspiration. Many of those states were attracted to and wanted to be admitted to the Council of Europe exactly as a gateway to the European Union. To the extent this is right, by the way, it may help explain the unusual willingness of the UK government to challenge the authority of the court on principle, since British identification with Europe has always been somewhat attenuated. The second, and maybe more powerful factor that seems to support the authority of the court, is the peculiar force of the human rights idea in our time. Although the meaning of human rights is rarely examined with much analytical rigor, at least in this forum, there is nonetheless a gross attachment to it that I think is nearly universal. That is, you won't find any state anywhere that is willing to take an overtly skeptical attitude when it comes to human rights. Something which can't be said, I think, even of democracy. This is certainly, I think, is one of the most remarkable political legal changes of our times. The subordination of national sovereignty to international human rights concerns may have been revolutionary at the time of the Nuremberg trials, but it has now been assimilated into publicly held values all over the world, and certainly in Europe. So, as a political matter, I think it's going to be extremely difficult for the UK, or any state for that matter, to separate the institutional question of who decides with the substantive question of respect for human rights. They're not going to be able to maintain their image as respecters of human rights and at the same time dismiss the authority of established international human rights institution. So I think it is unthinkable that the UK will, in the end, not without some kicking and shoving, but at the end I think it will go along with the European human rights idea. Thank you.
May I start with a brief personal remark? I would really like to thank my dear colleague John Wrights for putting this together. He has put me on the list of co-organizers, and I feel I don't really deserve it. He has done really most of the work. So I would like to acknowledge this here publicly. When we talk about the European Court of Justice, we talk about something that goes to the heart, the self-understanding, and the pride of Europeans. And this makes it difficult to talk about it. Because there's one thing that the European Court of Justice has done for Europeans. It has put Europe on the map of legal systems. It has put the European Union system on the map of legal systems, where it has become so important that European Union law is even taught in American law schools. And we owe it to this court. And Europeans for a long period of time have, with an attitude of deference and gratitude, looked at the court as this one institution that has given Europe a legal prominence that is otherwise only exemplified by the Supreme Court of the United States. So my remarks today will reflect a change of attitude that you can observe in the European Union towards the court. Because as you will see when I get into the questions concerning the future of judicial review in the European Union, Europeans tend to look at the European Court of Justice now with a more nuanced and critical attitude. But let me start with the topic, the European Court of Justice and judicial review. The question is there a counter-majoritarian difficulty? And if there's a counter-majoritarian difficulty, where is it? Now, if you go back into the history of the adjudicative practice of the European Court of Justice, you will realize that amazingly, on the level that we would describe here as the federal level, there is less of a counter-majoritarian difficulty than in the relation to the member states. If you look at the relation to the member states, there's not just a counter-majoritarian difficulty in the way we encounter it here, in the sense that a court overrides legislation. There's a far more massive counter-majoritarian difficulty because the European Court of Justice has created a legal structure that has effectively disempowered national parliaments in the Union. Now let me start first at the federal level. Why is it at the federal level different than if you look at the level in the relationship between the federal level and the state level, if you may use this terminology? The European Court of Justice does many things. Among the many things that it does is that it reviews the validity, decides over the validity of European Union acts. Acts of Parliament and the Council are, acts of the legislature, are subject to this type of judicial review. This type of judicial review raises usually two questions. The first question is, was the right legal procedure chosen? And if you are a little bit familiar with how the European Union legal system works, you will realize that until recently there has been a great variety of different legal procedures that you could use to adopt legislation. The question that was put before the court often was the question, has the right procedure been chosen? Have all the actors that have to participate pursuant to the treaty actually participated in the legal procedures? And when it came to this, there's a rich jurisprudence that is very complex, very difficult to understand, and the European Court of Justice, I think it's fair to say, in cases of doubt, has always ruled in favor of the European Parliament, was always favoring more participation by the European Parliament. So in this respect, the European Court of Justice didn't raise a counter-majoritarian difficulty when it comes to parliamentary participation because it supported the position of the European Parliament. Now things look completely differently when we look at the vertical dimension, the allocation of powers in relationship between the European Union and the member states. Here, for a long period of time, the European Court of Justice basically rubber-stamped everything that the European legislature did until we came to the very important to the tobacco advertisement cases that were decided by the European Court of Justice, and it was in the tobacco advertisement directive cases that the European Court of Justice for the first time actually invalidated the European Union Act on the ground of its interference with member states' competence. However, it did so by introducing a theory that made it in the future easier for the European Union legislature to use Article 95 to regulate the internal market. I'm sorry, I don't know the new number of Article 95 today. All right. So, federal level, friendly to the European Parliament, however, not really friendly to the member states. This gets me to the second dimension, for which not the actions of invalidation of European Union acts are actually relevant. The most relevant procedure before the European Court of Justice that actually affects the scope of powers that is left to the member states is the so-called preliminary reference procedure. The preliminary reference procedure is a procedure where national courts ask questions about the interpretation of European Union law, and the European Court of Justice divines the answer. I will get back to this point a little bit later. So in the course of this procedure, the European Court of Justice has given the European Union Treaty a structure that has severely constrained the powers of national parliaments because it has done something that was then called by scholars like Erich Stein or Joseph Weiler the constitutionalization of European Union law. European Court of Justice took out the magnifying glass, interpreted the treaties, and found something that wasn't written on the face of the treaties. Treaties have direct effect, treaties are supreme. The member states' governments realized as a result of this development already in the 1970s, 60s, 1970s, that if European Union law is supreme and directly effective, we can use European Union law in order to solve problems that we cannot solve at home, not only because of the scope, because we are confronted with political opposition. So the European Union actually offered an avenue for political problem solving that would bypass the national political process. This is the structure that the European Court of Justice created. The members of the Council gratefully acknowledged it. I simplify the story in order to get my point across. And at the end of this, we get national parliaments that are confronted with a constitutionalized European legal system. This is the story about the European Court of Justice as the hero of European integration. The Siegfried of European integration that kills the dragon of national sovereignty and takes the ring of power, in order to take it from the sovereign nation state and to do something with it. Didn't return it to the people yet, but the ring of power is now in the possession of the European Court of Justice. Now, the European Court of Justice did all these things by engaging in a style of legal reasoning that is, to say the least, surprising from the perspective of a European legal scientist. It discovered direct effect and supremacy by claiming, well, if you look at the substance of the treaty, it has to be directly effective. The same argument, by the way, could have been made, that the court made about the European Community Treaty. The same argument could have been made about any human rights treaty. If you look at the substance of the Human Rights Treaty, you realize it's of direct interest to the parties concerned, therefore it has to have direct effect. Did not so in the case of European human rights treaties, but it did so in the case of the European Community Treaty. The court discovered that non-discriminatory obstacles to trade violate rules that are intended to prohibit discriminatory obstacles to trade. So, you have a non-discriminatory obstacle, or it violates a rule that was intended to protect against discriminatory obstacles. The European Court of Justice discovered that if you cannot do business with the laws that you find in your own member state and find more business-friendly laws in another state, go ahead, import these rules by creating a company in a different member state and operate this company in your member state. It has thereby created something that because I happen to be a little bit familiar with the history of American constitutional law, called the European version of economic substantive due process. We owe it to the European Court of Justice. The European Court of Justice discovered that an international agreement can give rise to horizontal direct effect, free movement of persons, for example. Now, if you look at this from the perspective of a traditional European scientist who believes in the interpretation of legal instruments, pursuant to certain methods that you use of interpretation, if you believe in conceptual differentiation, and all that goes along with what is considered or used to be considered sober legal reasoning in the European Union, all of this is surprising. All of this is cast in the terms of political theology, the equivalent of a miracle. The European Court of Justice worked miracle. It worked substantively miracle, however, and that's the genius of the court, by adopting the demeanor of the law professor. What I mean by this is adopting the demeanor of the law professor was, you answer questions. There are questions of interpretations that you're posed, and you are in the position of the law professor and explain what it means. It does so with the demeanor of the law professor because if you have ever looked into the way law is taught and communicated on the European continent, you will realize that textbooks matter. Textbooks give you only very, very short reasons underpinning the opinions that are expressed by the professor writing the textbook. So that the textbooks are a little bit apodictic when it comes to this. The aesthetics of the textbook must have helped the European Court of Justice because it recreated the aesthetics of the textbooks in its opinions. Because the opinions don't give you much reasons, but they give you the authoritative view of what the law is like, and this is what you get in the textbook from the European law professor as well. This is the period of the heroic court, and the heroic court moved forward, following the maxim that Gian Domenico Margione has called of the maxim of crypto-federalism. And it's very easy. More Europe. To this day, we encounter this maxim, not in the European Court of Justice, but actually among European politicians. We have a crisis. We have a sovereign debt crisis. What's the solution? More Europe. This is the genius of crypto-federalism. Going forward, by the European Court of Justice has re-enchanted legal thinking in the European Union, because the European Court of Justice has worked miracles. The question is, does this have a future? And I identify three real problems. First problem, the problem of political economy. The European Union is not a homogeneous society in political economy terms, and this means that you have a variety of ways of organizing capitalism. Until recently, Europe has not believed in laissez-faire. It's organized capitalism. Therefore, you get different degrees of state involvement, different modes of stakeholder participation on different levels. Therefore, different corporate laws and different ways of organizing social risks. Political scientists are always very good at coming up with elaborate classifications, and I think political scientists have identified up to, 15, 17 different social models in the European Union. But when Fritz Schaub communicates to the larger public, he says, by and large, we have liberal market economy and social market economies in the European Union. So an example of a liberal market economy would be for the United Kingdom, and the example of a social market economy would be Germany or my home country, Austria. What has the European Court of Justice done? It has done the following in cases dealing, first of all, with corporate law in the European Union, and secondly, with the role of trade unions when it comes to hindering the exercise of freedom of establishment and freedom of service provision. The European Court of Justice has given the economic interests of the businesses engaging in service provision or moving around in the European Union greater weight than the interests of trade unions, even though European fundamental rights law would acknowledge that there is something like a right to strike or industrial actions. It has raised, therefore, the suspicion that it has taken sides in the European Union in two ways. Not just taking the side of the liberal economic model, the liberal social model. This doesn't surprise us. The European integration process is based on certain principles of ordo liberalism that you can identify and you can interpret in different ways. No, it has actually taken side in a conflict that has split the European Union since the largest enlargement between West and East. So you get from the Westerners, from the Western legal scholars and political scientists, critique of the European Court of Justice, whereas legal scholars from Eastern European countries start to defend it, because they think that greater freedom of movement that goes at the expense of trade unions in the Western European countries is something that will benefit them. Political economy, the European Court of Justice is torn into this conflict, which is actually a conflict between West and East. It may be politically incorrect to speak of East still in the European Union, so I should say actually West and Central Europe. Yeah? Okay. Second point, resistance. There's an ingenious jurisprudence by, well, there used to be an ingenious jurisprudence by the Federal Constitutional Court of Germany in the 1970s, where the Federal Constitutional Court actually identified the limits to the supremacy of European Union law. It has become less ingenious over the years, and I think in the Lisbon Treaty decision this is all going overboard, but still. Now this is a jurisprudence that radiates in the European Union, of course also into other member states. They read it. And actually the Federal Constitutional Court goes at pains to have its opinions translated because it believes that the wisdom of the Federal Constitutional Court needs to be shared with everyone else in the European Union. So, the Federal Constitutional Court has at several occasions said, we will, at a certain point, decide that European Union law is invalid on our own constitutional grounds if. But what the European Court of Justice, the Federal Constitutional Court has done so far was only barking without biting. So the result is that a member state court of a new member state of the European Union has started biting. And not the Federal Constitutional Court, because it followed the example. This is what happened this year in the Landwehr case in the Czech Republic. The facts of the case are terribly complicated because they deal with different pension systems that were introduced in Slovakia and Czechia after the division of the former republic. And the short story is that the Constitutional Court of the Czech Republic found that the decision reached in this case by the European Court of Justice is null and void. It is null and void because the European Court of Justice attributed meaning to the European Union treaties that is by no reasonable measure attributable to it. Resistance. First signs of real resistance against the European Court of Justice. Third point, predicaments, perplexity, fundamental rights, the case of Hungary in particular. There's great concern in the European Union that not only the sovereign debt crisis is something that may severely undermine the foundations of the European Union, but also the fact that member states may take a direction in their internal affairs that actually makes them look less than like constitutional democracies and more like something that we know from Europe's not so glorious past. One reply to this development was a theory that was developed in Heidelberg under the guidance of my dear friend Armin von Bogdandy. A whole group of scholars followed him. I'm inclined to call them the Arminians. And the Arminians believe that the European Court of Justice should step in and to protect the fundamental rights of the Hungarians against their own governments on the basis of the fundamental rights of the European Union. Now, the proposal rests on foundations, again, if you look at it from the perspective of the law professor that doesn't present his insights in a textbook, but actually reasons by taking one step after the other in a sober way. If you take this perspective of the law professor and look at the proposal that was made by Armin, it is quite audacious in the way that it deals with existing European Union law. So the question is whether it has a sound foundation. But actually, if you look at the history of the European integration process, law in the European Union was used as a means of social engineering. So the question is, would it be good social engineering if we made the European Court of Justice open this door for Hungarians so that the European Union fundamental rights can be used to protect them against their own government? It's a question of social engineering that we're talking about, and therefore it's a question of political prudence. I'm not very good at answering questions of political prudence, but here's what the stakes are. I think that the Hungarian government, which is in all its, with all its problematic features, but from a Machiavellian perspective, quite brilliant, yeah? The Hungarian government would use, I'm afraid, any step that is taken by the European Court of Justice as a means to alienate the Hungarian population further from the European Union. So I wonder whether this would be taking the step to offer European Union fundamental rights to protect citizens of their own member states against their own government. Whether this would be a step into the right direction, I would find it doubtful. But these are the challenges that the European Court of Justice is confronted with. Resistance on the part of national courts, the political economy question, the unresolved political economy question in the European Union, in which the European Court of Justice has already taken sides, and then the predicament posed by countries like Hungary. All right, thank you very much.
I want to start by adding my thanks to the organizers, and particularly Professor John Reitz, for including me in this meeting. I hope it's not too churlish to just note two small critiques. One is, I'm not sure how comfortable I feel following up on two such thoughtful and outrageously eloquent presentations. I feel a certain amount of, I know the door is almost close enough that I might flee. The second is putting me in a position to talk about Chinese law in front of Professor Jin Chengdong of the Zhejiang University Law School, a top expert in Chinese administrative law. I feel a certain level of examination here as well. So, other than those two, I'm very grateful to be here. My task, I suppose, is to introduce the Chinese example into this overall discussion, both of this panel and the conference altogether, with a particular view towards how judicial review may or may not serve a legitimizing or even substitution function under conditions thought not to be sufficiently legitimated by electoral democracy. And also whether the existence of judicial review under such conditions might serve to facilitate transition to electoral democracy. I should note also that I'm a comparativist who focuses on administrative law, and in that regard I feel I have a special responsibility to underscore the salience and particular contribution of judicial review of agency action within an academic discourse that typically is focused upon and privileges constitutional judicial review. I believe the story of the introduction or the emergence of judicial review of executive action by different regimes over time is no less dramatic and consequential than the establishment of constitutional courts. And I believe the literature that has developed around the issue of constitutional judicial review and the various contours of the problem that have been demarcated to a surprisingly large degree fail to incorporate deep consideration of the particular dimensions of judicial review of executive action. And I'll take my teacher and someone who I hold in immense regard, Jeremy Waldron, as one example. So if you look at his his Yale piece, he has just a few lines on judicial review of agency action, and these are the 3 points he makes. He says, first, on the one hand, it might be thought that some of the same arguments that he's making against constitutional judicial review apply to executive action as well. After all, the executive has some elective credentials of its own with which to oppose decision-making by judges. Okay, point one. Point two, he says, but on the other hand, the executive's elective credentials are subject to the principle of the rule of law, and so officials may properly be required to act in accordance with legal authorization. Okay, maybe that's the bottom line. But no, there's point three. He says, and yet, when I'm prompted to consider statutes enacted long ago or whose provisions require extensive interpretation by courts, well, maybe my argument against constitutional judicial review applies here as well. And that's basically all he says, and he moves on. So just taking that as one example, I think this may be an area that is somewhat under-theorized, and so I hope that the story that I'm telling can help somewhat to in the context of this larger discussion about constitutional judicial review, help to flesh out this relationship. I think that I probably should spend a little bit of time just describing the Chinese model before we get to some maybe more theoretical points. In China, judicial review of agency action is something that emerged gradually in the aftermath of the Cultural Revolution as China began to engage in this reform and opening up period alongside a general reconstruction of the Chinese legal system. And it emerges, like in some other countries, but to some extent unique to China, out of a combination of official state interests in monitoring local officials, combating corruption, sending signals to foreign investors, a personal experience of certain Chinese state leaders during the Cultural Revolution, which maybe especially attuned them to the problems of abuse of power, and finally, amidst what is generally regarded as a particularly open and vibrant period of time in Chinese political life, out of a distinct transformative agenda on the part of newly empowered legal elites, especially legal academics. And this effort, which is itself a fascinating story, ultimately culminates in the passage in 1989 of the Administrative Litigation Law, formalizing procedures for citizens to sue the government, which is passed just a few months before the Tiananmen Square incident. And in fact, just after passage, you have Tiananmen Square, and there was some real threat that it would be rescinded in the political environment after Tiananmen Square. And one of the indicators of what a strong lead-up it had been to passage of the Administrative Litigation Law is that it actually survived that period of retrenchment. Now, the power of judicial review of agency action that was delegated was to these newly constructed administrative divisions within the general judiciary. And this is a judiciary that's bureaucratic or hierarchical in the civil law sense, but has additional bureaucratic elements that are somewhat distinct to China, like adjudication committees, which are small committees within the court at each level of the court system that are composed of a given court's leadership, and in many cases really decide the cases behind the scenes and instruct the judicial panels how to rule. The actual power delegated to administrative divisions within the judiciary was a very limited one. It's a review only of specific administrative acts and not the general legal norms upon which those acts might be based. And it's a review which is not really supposed to consider the reasonableness of agency action. So it's a model that really evokes Merriman's description of the traditional or the mythical role of the judge in civil law systems, merely to find the legislative provision, couple it with the fact situation, and bless the solution that is more or less automatically produced from the union. That said, there is a slight terminology in the text of the Administrative Litigation Law that is then expanded through official and scholarly commentary, which does give judges in administrative cases the ability to do a form of review of general legal norms. And in particular, judicial decision makers can choose not to apply, in particular cases, certain lower level legal norms that might conflict with higher norms. The normative hierarchy under Chinese law goes constitution, law, regulation, rule, normative document. And what judges can do under the administrative litigation law is choose not to apply that level of rules if they conflict with higher level law. Now, not to apply doesn't mean to invalidate. And in fact, a few years ago in a civil case, there was a judge who tried to resolve a conflict between rule and a higher level law in that case by not only not applying the rule, but going forward and saying that that rule was invalidated and that judge's career is over. And that case has been basically a standalone case that doesn't seem to have continuing relevance. Let me just take a moment to say something also about how the system then deals with normative conflicts, given the apparent inefficiency of the judicial review. According to the text of the administrative litigation law, certain types of conflicts are referred by courts to the executive branch, the state council, for further interpretation and ruling. That type of approach is then carried forward through a later state council regulation, which addresses another level of normative conflict, and again says that citizens can submit these to the state council for interpretation and ruling. And then under the law and legislation, which was passed in 2000, there's a new procedure by which citizens, in fact, as well as state organs, can petition the standing committee of the National People's Congress with claims that regulations violate laws or the Constitution. So it's not, there's nothing in the Chinese system that permits you to claim that legislation violates the Constitution, but you can claim, according to law and legislation, that regulations violate the Constitution or law. And what was established in the course of the law and legislation and including this provision was a special office within the National People's Standing Committee, the National People's Congress Standing Committee, which reviews these petitions. And we don't know enough about the office. There's obviously a lot of interest in understanding who staffs the office and how exactly they work. I've been told it's something like 13 people, but I wouldn't write that down. I don't know that that's exactly right. I've been told that the office doesn't decide cases themselves, that they serve more of a function of getting these petitions, then maybe sending them out to functional committees with the NPC, and then in some cases maybe speaking to the bodies that originated regulation about possibly changing it, but there's nothing decisive there. So now I get to, is there anything in any of this that sort of indicates constitutional review? And there has been a lot of interest, both among Western scholars of Chinese law and among Chinese academics in developing a system of constitutional review, and in large part because the 1982 Constitution, which does primarily serve to enshrine the political leadership of the Communist Party, it does also contain a very long list of quite robust civil, political, and socioeconomic rights. And so there is this ongoing notion that it would be great to have these rights be part of the toolkit for citizens to challenge government action. There has been an ongoing scholarly discussion about creating some kind of a constitutional council within the NPC Standing Committee, or even parallel to the National People's Congress Standing Committee, which could serve this function of constitutional review. And that's basically a scholarly proposal. It's not going anywhere. The closest thing that might look like that in the entire system is that office within the NPC Standing Committee that I just alluded to, this office that is empowered to review petitions claiming that regulations violate the Constitution. But for that to become something like a constitutional council requires many more steps. As far as constitutional review by the ordinary judiciary, this has been essentially a non-starter. Sometimes there have been claims that sort of look like constitutional claims smuggled into administrative litigation. I wouldn't really put too much stock on that. There was a very interesting incident about 10 years ago where a lower court, which was confronted with a claim that a constitutional right to education applied in a case before it, the lower court then asked the Supreme People's Court if that constitutional provision applied, and the Supreme People's Court remarkably issued a formal reply saying that yes, the Constitution did apply in that case. And this generated a lot of excitement and a lot of discussion. That was 10 years ago. What's happened since is that the formal reply to the Supreme Court has been formally withdrawn, and the Supreme People's Court Vice President who issued the reply has been sentenced to death. Now, there's a couple of steps between those, but these are not completely disconnected steps. So, for something that would be more robust that'll all take some time. And so in the absence of formal mechanisms for constitutional review, outside of the petitions about regulations to that office with the Embassy Standing Committee that I talked about, whether the civil and political and economic rights under the Chinese Constitution are vitalized really to this point depends on official and popular discourse. And there's quite a lot of that, and it's something that many of my colleagues who study Chinese constitutional law in particular take very seriously, often drawing upon our literature about popular constitutionalism. Now, when it comes to administrative litigation, which is what I want to spend the rest of my time talking about, I personally take discourse very seriously myself in ways that I'll explain in a moment. But to be perfectly honest, I'm not quite sure what I make of these arguments about popular constitutional discourse when they're really disconnected from any kind of formal process. More broadly, I do feel, as I sort of alluded to at the very beginning, that the actual practice of administrative litigation and judicial review of agency action under the administrative litigation law in China is a very rewarding focal point. Even though Chinese laws and regulations are not produced through genuinely participatory processes and basically are not subject to any sort of post hoc constitutional review, I believe effective judicial enforcement of their content against executive action would be a quite significant step in and of itself. And the prospect raises the tantalizing possibility of a culture of liberal legality. I go out of my way not to use the terminology of rule of law. So that's what I'm saying, but I'm trying not to use those words. So the possibility of a culture of liberal legality in the relationship between Chinese and citizens and the state, and hence meaningful restraint of government action even under non-democratic or authoritarian conditions. So how does it work? Does this actually live up to any of that promise? So I'll just take maybe about 4 or 5 minutes to give you a basic story of how administrative litigation works in practice, and then take a few minutes after that to give a basic story about how we might assess that. And so the basic narrative is the surface level. Are suits brought? Are the suits successful on their own terms? Are government departments meaningfully constrained either after the suits or in anticipation of the suits? The basic answer to that, obviously simplifying it and speaking quickly, is that while this is a functional system, it doesn't quite operate according to the formal design of how, if you just looked at the text of the law, it might be supposed to operate. Yes, there are a non-insignificant number of cases, now roughly about 130,000 per year. There are suits against every government department. Oh, 5 minutes, wow, okay, so I'll have to go even quicker. So there are suits against various government departments, and government departments have responded to suits in ways that we might deem positive by changing some aspects of their internal operation, legalizing their internal operations, and so forth. But there has accumulated considerable evidence of direct and indirect government interference applied both to litigants and to judicial officials. And this is in a context where we have very sharp concerns about judicial independence, both of particular judges, of courts, and of the system as a whole. And the overall number of cases does appear to be quite low. 100,000 cases in the country of 1.2, 1.3, 1.4 billion people seems quite low, especially when you connect it or you compare it to the number of petitions per year. The number of petitions, which is a non-formal system in which people can raise claims of government illegality or other government wrongdoing, is about 10 million petitions per year. So even if we don't think that every one of those petitions is necessarily a justiciable legal claim, 10 million petitions per year versus 100,000 cases per year seems to be quite a big difference. And in fact, it seems that there's growing recognition that citizens are dissatisfied with this mechanism, but they're not They don't trust this mechanism. And the legal scholars who have been involved in the very beginning in producing this mechanism are constantly in the process of suggesting textual revisions. And at the moment, the National People's Congress is considering amending the law, and there are scholarly proposals that very much expand all the provisions of the law that I alluded to, that suggest that jurisdiction should be expanded in different ways, that the level of review should be strengthened, that the type of court should be made more independent. And all of that's very well good, and as a scholar of this, I try not to get too invested. I don't think that's my role. Whether or not judicial review under the administrative litigation law should be able to invalidate any type of normative document, or whether the types of cases should be able to start at one level of court or another, I don't think that's my particular role to assess them. But it's interesting for me to note that this is something that is being proposed from the Legal Academy. Whether or not that will be successful, I'm not quite sure. What and I probably only have about 2 or 3 minutes, what I have ultimately thought is more important, independent of the precise way that the review under the administrative litigation law is constructed, and independent of whether or not the cases are won or lost, independent of whether or not the government necessarily changes its behavior in advance, what I have started to think is most important are the second order legal and political effects that have come out of the experience of administrative litigation. By legal effects, what I'm referring to are the empowerment of the community of law professors and lawyers and judges who've grown up around the presence of administrative litigation. That community in of itself, I think, has a real importance and significance. The way in which the administrative law regime has expanded, the number of substantive administrative laws that have been passed in the years since this initial book, the procedural law permitting judicial review of agency action, was passed. I think that's significant. And then moving more to political dimensions, this is, after all, a state-sponsored, state-legitimated forum for claims of contention against the government, and in an overall context in which contention is difficult to effectuate, having this legitimated forum for claims against the government to be regularized, normalized, I think is extremely significant. It's a focal point for communities of aggrieved interest who might otherwise have difficulty connecting or pursuing social action together. It's a focal point for them to connect, whether or not ultimately their cases are successful, whether or not their cases ultimately are even accepted. Obviously there I'm drawing on some of the literature in the U.S. on courts as a forum for social protest. And finally, the existence of this law and the existence of some cases gives commentators, and particularly academics, lots of opportunities to criticize the government in ways that seem somewhat indirect at times and hidden, but are no less real. And so to me, these are the most important aspects of the presence of judicial review of agency action in the Chinese legal and political environment. Where that ultimately leads is unclear. And also, I think, and this is what I'll close with, to the extent that the ongoing government resistance to robust administrative litigation has seemed to ratchet up in recent years, and I'm thinking of Tim's presentation yesterday, there may be a tipping point where the resistance is so strong that the second order political effects that I see are basically neutralized entirely. And that's something that, unfortunately, I'm increasingly concerned about.
Thank you. Never have I seen a panel that stuck so well to their time and still got everything said that they wanted to. Questions and comments? I'll start here.
I have 2 questions. A quick one for Neysun on the last year. Carl Minter did a piece on move away from law. I wondered how that impacted your thesis. And a quick question for Alexander. The Delawareization corporation as a corporate person, if I refer to it in EU corporate law. I didn't understand how that had the sort of broader impact in terms of worker rights and things of that nature. That might be too long to answer now. If there was a reference you could provide on that, would be useful.
How should we do that?
I would prefer to answer the question quickly because I'm not really an expert in corporate law. So may I give a quick answer? Yeah. It concerns mostly Germany. Yeah. Germany has a corporate law that, depending on the size of the company, yeah, on the type of the company, Germany has a corporate law that actually allows for stakeholder participation or workers' participation, so-called co-determination, on the level of which board, please don't ask me. But it is participation on the part of the workforce that you get in German corporate law. Now, this has been a thorn in the sides of all Germans who believe in true economic liberalism. Yeah? And they welcome, of course, now the opportunity to register companies in the United Kingdom and to build up a branch office in Germany and to work like this. And there's great concern that the German social model of stakeholder participation, not just on the company level, because it's something that you also encounter in the corporate political system in Germany, is something that has in decline, yeah, or is about to erode as a result of this development. So this is what I was coming from. Yeah.
So let me just say one quick thing about Carl. So Carl Minzner at Fordham Law School published this piece, China's Turn Against Law, in the American Journal of Comparative Law about a year or two ago. And it's an excellent piece, and I recommend it to everyone. So what Carl is describing is sort of what I alluded to at the very, very end, which is this recent sort of extremely, well, I shouldn't say extremely quite yet, this recent set of policies that seem to be undercutting formal adjudicative processes, and in particular through a couple of, or more than a couple of policy documents within the Supreme People's Court that are encouraging judges to engage in more mediation, and in fact the administrative litigation law, as drafted in 1989, expressly prohibits mediation, but mediation of administrative claims has become so prevalent that when they revise the law, the one thing that they're most likely to do is actually permit mediation. And so that's the phenomenon that Carl's describing, and this is all quite true, that there have been these policy documents, and judges at the lower levels and all the way up to the Supreme People's Court are increasingly feeling that they are not supposed to be judges anymore, that they're supposed to be mediators, and they want to be judges. They read about American judges. They think that's what a judge is supposed to be, and so they're and the one, and I told this to Carl himself, and he's a good friend, so I don't feel bad saying this here, is that I just, the problem is categorization. Turn against law sounds really final and black and white, and I mean, I think these are all things that are happening at the same time, and some of these policies maybe were rooted in earlier policies, and whether or not this really reflects a concrete shift that we could, using the Galanter language of turn against law. I'm just not sure about that, but the story that he's telling is otherwise, I think, quite good and quite true.
I've got a list. It's already got 9 people on it, and I'll try to go in the order I saw. The gentleman there in the middle.
Thank you. This comes directly from Sasha, as you might expect. I wanted to suggest actually a fourth development, and I wonder if you would think it belongs in that category of development that challenge the heroism of the European Court of Justice. Something I've been working on recently that I find extremely interesting. The EU is a little ambivalent. It wants to be king of its own universe, but it also wants to be an active international actor. And 2 things have happened that I think are generating some new tension for it, and you know what they are. The Lisbon Treaty requires it to become a member of the European human rights system as such, which means that it's untenable, from my point of view, that it can claim a special status, which it has enjoyed after the Bosphorus case, of getting indulgence by the Strasbourg court. Now, as a practical matter, that may not produce any difficulties because the jurisprudence on human rights of the 2 courts is broadly congruent. Right. So that's a theoretical issue. But the European Court of Justice can continue to distance itself from the High Court of an international legal regime of which it is a constituent member. Now, the other example is more serious, and something I've been working on recently, and it has to do with the Lisbon Treaty making foreign investment law and arbitration. which means that now the EU is not only a member of the European rights system, or about to be, but it's a member of the international arbitration system. And the member state courts are finding themselves under conflicting obligations. You're probably aware of that case that's now going on in Frankfurt, where, in fact, the court is faced with a situation in which we have a withdrawal of state aid, the state aid being illegal under EU law, but the withdrawal of the state aid being an investment treaty violation. And the member state courts are now in a little bit of a bind because they're not quite sure whether their membership in the EU trumps their membership in other genuine international organizations. So all that is a quick way to ask you this question. Would you agree that development exists, nascent, and how does it interact with the developments you've identified?
2 questions, 2 points. The first point, you're completely right. Yeah, this kind of Solange arrangement that the European Court of Justice and the European Court of Human Rights, or the Solange arrangement that the European Court of Human Rights actually proposed to the European Court of Justice, may no longer be sustainable. However, there is one thing that we need to take into account. If Joseph Weiler is right, and if you ask Joseph Weiler, he is right. The European Convention system tries to establish a minimum standard, and depending on, first, your national constitutional traditions or the type of polity that you are, you may in certain instances protect more in regards to fundamental rights than is actually required by the fundamental rights. But that's right. There's a trade-off, and we will see. Yeah, this is the answer that a lawyer can give you in these questions is we don't have seen a decision yet, so let's see what the future will bring. Yeah. So I don't know. But it is a new situation. You're completely right. It's a new situation. When it comes to the questions of our conflicts between obligations that arise under the European Union Treaty and international obligations. Wasn't it traditionally the approach by the European Court of Justice that there exists a certain priority of the European Union litigation? Right. Yes. And of course, any other international treaty regime will say, well, we have priority. Well, we are then confronted with the situation that many of my colleagues celebrate as constitutional pluralism in the European Union. So we are confronted with a situation of pluralism, and as a result of which, any court should try to find a solution that takes principles into account that we find in our international system, such as, for example, or in the system of the in our international system. Principles like the principle of proportionality with regard to the autonomy that may be claimed by the European Union. A principle such as subsidiarity may be of relevance to the resolution of these cases. I don't know. Fortunately, I don't have to decide these cases. But we are confronted with this situation where we don't have an overarching legal order as a result of it. Yeah?
I think there may be a preliminary reference from the Judicial to the European Court of Justice on this very conflict having pending.
Okay.
With regard to the relation between the European Court of Justice and the European Court of Human Rights, this has been, anticipated for some time. It was when the Lisbon Treaty first postulated this, there was some expectation in Strasbourg. It was to be very simple. The appropriate officials would come and sign the treaty. And in fact, it's now been, I think, 3 years still being negotiated. And so there will be, in fact, an accession treaty which will have which may or may not have all kinds of terms about this. But we do have this what you described, this very odd situation of states being subject now to 3 human rights regimes. There is their domestic human rights regime, the European Convention regime, and the European Charter of Rights regime as well, with a unclear hierarchy between them, or at least from an overall point of view, an unclear hierarchy. That is to say, as you appropriately said, to the extent that a national jurisdiction maintains the supremacy of its own constitutional order. There's a Solonga principle. So the European Court of Justice will have a Solonga principle with respect to the European Court of Human Rights. I would not exclude the possibility of there being some serious conflict. The European Court of Justice, the European Charter of Rights, is a much more extensive doctrine of rights, including a number of affirmative social economic rights, which one could easily imagine cases would conflict with some of the more liberal rights that are protected in the convention. So I think it promises to be a mess.
As a long-time opponent of, I won't say judicial supremacy because that doesn't exist, of courts that aspire to judicial supremacy, I've admired Abraham Lincoln's first inaugural address, where he responded to the Dred Scott case by saying he would comply with that, the parties in that case he wouldn't resist, but he wouldn't make it a principle for the government. In other words, he would negate any stare decisis effect. Of course, stare decisis was only beginning to enter into its vogue, its power at that point, so he could turn that away more easily. But anyway, that was a way of being legalistic and still resist the court. Now, it seems to me this is what Europe needs. The legalistic instincts of Europe don't want a direct showdown fight, high noon. There's some legal way out. But it seems to me the preliminary reference mechanism provides a way out, and I wonder if any courts or others are taking this. The preliminary reference mechanism is not, doesn't say there's stare decisis, doesn't say erga omnes even. It's just a reference for the interpretation of the treaty as applied to the parties in that case, and it's up to the courts, the national courts, to nullify statutes or to go beyond. And the European Court of Justice also said that stare decisis is optional. That is, well, not exactly. It expects compliance with stare decisis, but if a court wishes to refer the issue again to the European Court of Justice, it may do so to reinterpret the treaty. So it seems to me, for example, the German Constitutional Court could order massive resistance. If any of these cases come up where the European Court of Justice has misinterpreted the treaty, you cannot continue with that case. You must ask for another reference. And this would be a way of making it very uncomfortable to impose an interpretation of the treaty that the German Constitutional Court disagreed with without actually getting in a fight over legality. It's the same way Lincoln said, basically we're going to continue to give passports, treat black people in federal territories as free citizens. Their masters can litigate up the Supreme Court again and fight it over again, but they can do that. But it's going to be very difficult for them. So it seems to be a wonderful way of practical, legalistic kind of resistance. Is anybody doing that in Europe?
Well, if you look at the history, the Tobacco Advertisement Directive case would be one of my favorite cases, where the European Court of Justice must have realized. I look at it really from the perspective of social engineering now, not of legal doctrine. But the European Court of Justice seemed to have realized that Germany has strong misgivings over whether the European Union has the power to adopt this directive. And it was in this case that the European Court of Justice, maybe in anticipation of what Karlsruhe might say, said, yes, indeed. This is in a case where the European Union has overstepped its jurisdiction, and here are the principles that you need to follow if you want to use the harmonizing power for the internal market. So I think there are cases where you can see this mutual deference, not directly articulated, because everything has to be presented. Aesthetically, it has to be law, So it has to be presented as legal interpretation. But in fact, of course, it is striking a balance between the claims made on the part of member state courts and the European Court of Justice. Now, there are cases where this doesn't work so well. The Mangold case that outraged Roman Herzog, the former president of the Republican president of the Federal Constitutional Court. The Mangold case was the case that actually gave rise to a long litany by Roman Herzog in which he complained all standards of legal reasoning are disregarded by the European Court of Justice. So It is difficult, and I don't know the European Court of Justice from the inside. Yeah, so Miguel Maduro would be a better person to ask. Yeah, what the institutional ethos and what the self-confidence is that prevails in the court. Yeah, it really depends. Yeah.
Tim Sellers from the University of Baltimore. I have a question about the legitimacy of courts. I think everyone uses the word that's probably directed primarily to the case. It seems to me that for the most part, the normative legitimacy of international courts, and indeed the authority of any court, is not primarily based on democracy, but rather on the expectations that the court is going to answer legal questions well. And that applies also to judicial review, which are really under Keynes and is not essentially connected to democracy. So the question about the European Court of Human Rights, for example, is will it answer legal questions well? And I think there are two criteria to be applied here. First, is this a good topic for international courts? Is this the sort of thing that should be resolved at the cosmopolitan rather than at the parochial level? And with respect to human rights, yes, because human rights are universal, and I think it's always better to push it up the ladder if you can. But second, the quality of the court, and that's much more problematic, and that's the criticism of Jack Straw. The European Court of Human Rights, is it in fact likely to get things right, or would it be much more more likely to get better, more accurate answers than British courts? And that would depend on the culture of the court, and I think to a large extent on how judges are selected and so forth. And so I wanted to throw out, I suppose, that second question: how do we judge? How do we respond to Jack Straw, who challenges the European Court of Human Rights? He just doesn't think it's a good court.
Yeah. I think to the extent that that the worry is simply that they're getting the judgments wrong, that presupposes, first of all, that
they're likely to because of the structure.
Yeah, I mean, in a way, that's just a matter of record. That's kind of not what that's not the way the popular criticism usually goes. That is, there's no popular. It's rather almost always directed at a specific decision. But certainly one could generalize from that and make that argument. Let me say two things about it. One is, notwithstanding what you say about the legitimacy of the court arising from its ability to get the law right or wrong, there is a sharp democratic argument in these criticisms, and that is to say, this is a policy which needs to be made here at home by our democratically answerable institutions. So that whether that makes sense or not, given that you've already signed up to a legal regime which has certain standards. As to the kind of long-term capacity of the European Court of Human Rights, I think there has to be there has not been, maybe related to the first thing I said, there has not been a systematic attack on it. Rather, the general record has been considered praiseworthy by almost all of the states involved. Needless to say, their critical capacity becomes sharpest when it's a judgment against the state involved. But when, in fact, they're asking Russia to essentially put a partition in the toilets in the prisons, everybody agrees that they're doing just a fine job, except the Russians. So I've kind of wandered off your subject. I did want to say one thing related to your first point, and that is, to the extent that the legitimacy of the court depends on accurately representing the governing law, that requires that the governing law itself be legitimate. Okay? And I think that is a matter which has been under-theorized in the case of international human rights law. And if, in fact, it was better explained, and if we had confidence that that explanation was universally accepted, then the argument you made, I think, would have more force.
Our other two panelists wanted to say a word on this.
Yeah, just one idea. What is the European Convention system? How would you explain it to someone who is not a lawyer? My explanation I mean, it's not something that you can use for ordinary people either, but we are familiar with it. It's a system of peer review. Yeah? You submit yourself to the judgment of your peers. This is painful, as well, I particularly know, because my peers never understand what I write about. Yeah? But you accept it because but you accept it because you are, after all, trying to write for them, or it matters to you what they think of you. It really matters to you. It's a quality control that you submit yourself to. Yeah. But this presupposes, in the international context, something, and I may sound like Carl Schmitt, and I no longer mind. Yeah, I'm in the 21st century already. Homogeneity. You have to be sufficiently similar, and that's the problem that you encounter in the European convention system, of course, and that's the problem, I think, of the criticism that was voiced by the Britons in particular. Who are they? Yeah, to tell us. Yeah, so that's the homogeneity. If you grow too large, you become too heterogeneous in order to have a sufficiently plausible basis for the system of peer review.
I just wanted to jump in on this. The way that the question was formulated, I thought was very provocative, and the notion of answering questions well, I think might be more profitably explored in judicial review of agency action, because I think that the question in constitutional law it's harder to, well, what's the right answer, but in administrative law it's still hard, but at least we can get a little closer, saying there are more right or more wrong answers. I think this was sort of, if I'm not mistaken, this was sort of brought up. This type of question was brought up in Rand Herschel's initial presentation, and sort of disconnecting judges and courts operating from effectively from the notion of democracy. And I guess the one thing that is I think maybe well-traveled ground, but I felt I should say here, is that it's hard for me to see how they answer questions well without independence. And it's hard for me to see how they have independence without, and independence, there can be a variety of forms of independence. This is something that sometimes I think, and for this I'm really influenced by a review that Frank Upham wrote comparing the work of John Owen Haley and Mark Ramsar. And if you look at the Japanese Supreme Court, it's independent in ways that don't look like maybe the American Supreme Court, but that doesn't necessarily matter. So there's a variety of forms of independence, but without some degree of independence. I'm actually sort of, I'll pose it back to, if people want to talk about this later, I don't know of many examples in history where you have questions answered well because there's some degree of prestige and independence associated with the court outside of purely in purely authoritarian context. And the only example that immediately comes to mind might be like the Conseil d'Etat as it's emerging. But the story of the Conseil d'Etat rising prestige sort of matches sort of political liberalization in France too. But I'm not a French.
Let me say one thing about groups. I want to respond to what Alexander said about peer review and what I think a very acute and accurate statement of the problem. But I think given it's related to what Tim said, because the suggestion of what's the appropriate community for peer review, Tim's question presupposes, since this is a human rights regime, the appropriate community is human beings. So that at that point you could simply say, well, are you a good articulator and people are entitled of those universal human values? But again, there's a great distance between that and the way they're actually proceeding.
So Professor Reitz tells me that the bus is leaving at 12, so that I have to bring this to a formal end. But that doesn't mean we have to stop with the questions. But let's thank the panel. And then let me tell you, the order was this little woman in the third row, and then these three gentlemen, all three of them in that row, were up next. So if you want to fight to come down and fight.
I guess it's a good conference when there are lots of questions and lots of desire to discuss. So please continue discussing. I just want to say two things. One is Dr. Somek mentioned that I keep forgetting to thank my committee that helped me organize this, and despite what he said, actually they both helped me a lot. It was Professor Somek and Adrian Wings. They were very helpful to me in this thing. And then the other thing is lunch is right around the corner.
Thank you very much.